All right. Hello, everybody. Thank you so much for joining me today. I hope that everybody can hear me. I really like talking in presentations and interacting with fellow entrepreneurs. One of the things I don't like about the Zoom format, though, is that I can never see anybody. And it's hard to communicate with other people when there's just a bunch of people in the audience and then me on the screen here. So while we're in this session here, feel free to chat in the chat box. In fact, if you have any questions during this session, feel free to put your questions over in the chat box. You can either share it with everybody or you can share them with just me. You can also use the Q&A feature if you really want to, but I think the chat box will work just fine for this event here. So, oh, got a question already. Oh, chat's disabled. Well, that's a bummer. Okay, well, the chat is disabled, but at least you can hear me. So here's what we're going to do. I'm going to close the chat box and keep open the Q&A box. So you are welcome to put your questions into the Q&A box. Thank you so much for letting me know that. Okay, so let me tell you a little bit about myself and then we'll jump into the contracts. I've been, and actually while I'm doing this, oh, I don't have chat. Okay, never mind. I'm just going to assume that you are all creators in some format. I was going to have you tell me what you did in the chat box, but don't flutter the Q&A with a bunch of comments about what you do because that'll just mess up the Q&A, I think. So anyway, about me. So my name is Chris Brown. First of all, I've been involved with Global Entrepreneurship Week for a very long time. It's a super cool program. I even have this cool little pin that they gave me years ago that I had to keep on my monitor all the time. I live in Boulder, Colorado now. I actually don't live in Kansas City any longer, but I spent the last 15 or so years in Kansas City and I went to law school there. I started my own law firm about 10 years ago. It's called Pixel Law. Previously, it was called Venture Legal. In the years since, I've also started and sold two other businesses. One was a legal marketing company. The other was a digital contract creation tool for freelancers. Today, though, I'm just a lawyer. I run Pixel Law. I represent entrepreneurs. I do contracts, LLC formations, trademarks, website terms of service, and all of that stuff. And primarily, I work with creators. Most of my clients are creative in some capacity or another, website developers, software developers, marketing professionals, business coaches. I do have a small number of coffee shops and t-shirt businesses and other things, but mostly what I do is work with creative professionals. And like I said, I spent most of my time in Kansas City, but now I'm in Colorado as a result of the pandemic, and I'm growing my firm here slowly but surely. But something like 95% of my clients are still based in the Kansas City area, and I still come back quite a bit for family and work and friends and everything. So today we're going to talk about three primary topics. First is Contracts 101. Second is we're going to walk through essential contract terms that are really important for creative professionals. And then we're going to talk about how to review and negotiate a contract. And like I said before, and more people keep joining here in the last few minutes, so I just want to reiterate this. If you have questions, please put them in the Q&A box. Apparently chat's disabled. I love the Q&A and the feedback and the discussion that we have. It's kind of hard to do on Zoom, but the Q&A box will work just fine. So if you have questions throughout, just throw them in whenever you have them. Okay, so let's jump into Contracts 101. Now, at the most basic level, a contract just requires three things: an offer, acceptance, and consideration. It's consideration, but it's just something of value. Like you have to give something to the deal. This could be as simple as, you come up to me and you say, "Hey, Chris, I hate your website. I want to build a new website for you. I'll build you one for $500. Okay, and I say, "Great, get to work." We have a contract. It's not in writing, but we have a legally binding contract. If you don't build it, I can sue you for breach of contract. If I don't pay you, you could sue me for breach of contract for not paying you. The offer was you came to me and said, "Hey, I'll build you a website for $500. The acceptance was me saying, "Sure thing, get to work." And then that last prong there, consideration, there's something of value. The thing that you're bringing of value is you're building the website. So that's your consideration. The thing of value that I bring to the table is the money that I'm giving you. So we both provided consideration. There was an offer and acceptance. So we have a contract, and that's really about it. Now, there are some situations where you have to have a contract in writing. So if it's like a prenup for a wedding or a real estate deed, trusts and estates and things like that. So there are limited circumstances when a contract just must be in writing. But for the vast majority of contracts, and especially contracts that you're likely to come across as a creative professional, you generally don't need a written agreement. With that said, and I'm a lawyer, so of course I'll say this, you need to put your contracts in writing. Don't rely on oral agreements. If nothing else, after that exchange, shoot me an email. "Hey, Chris, I'm so excited to build your website for $500. I'll get started tomorrow. Can you reply to confirm?" right? Try to get some kind of an email exchange so that both sides have agreed on what the actual deal points are. I mean, that's the bare minimum. But what you really should do is put it into a written format. And so why should you do these contracts? Why is it so important that you do this? And the fact that you're in this session here today is a good start. Well, I think that they dramatically increase your odds of succeeding as a creative professional. This is true for freelancers, for small businesses, big companies, whatever. The odds of succeeding go up because when you go through the process of creating a contract, you have to talk through all the what if scenarios. You have to talk through the, how do you get paid? What's the time period? Do you take credit cards or just checks or cash or Bitcoin or whatever, right? And by going through those steps, it forces the parties to kind of figure out the deal and reduce the odds of having a dispute in the future, which is the second point there, which is minimize risk. So you're reducing the odds of a dispute. And if a dispute arises, hopefully your contract allocates different risks to the parties, which makes it easier for you to resolve those disputes, which is point three. You might have an arbitration provision or a mediation provision. You might have choice of law and which court you're going to use and things like that. But on top of all of that, just having the contract means if you go to a lawyer to get help, well, the lawyer can review the contract and it's going to make it faster and easier for you to resolve it instead of having to prove what the actual deal terms were in the first place. Now, you might be wondering, where do you get a contract? And I'd like to think of this as there's basically three options in the modern world. First is just draft your own. And a lot of people might think that's crazy, but I'm not one of them. I think drafting your own contract is fine. It's not going to create the best contract probably. But hey, if you write down, here's what I'm going to do and here's what you're going to do, and you both sign it, I mean, you are already leaps and bounds ahead of a lot of people. So do that. And you can look up finer details online. I'll talk about some provisions and give you examples here that you can use. So it's totally plausible that you could do it yourself. Next up is hire a lawyer. Normally that will result in the best end result, the best contract, but that's not guaranteed. Plenty of lawyers draft awful contracts. It's amazing what I've seen out there. So usually the best case, but not always the best. And it's usually going to be the most expensive though, right? So sometimes people cannot or don't want to pay the money to do that. And that gets me to the third point and the third option, which is just to buy a template online. And for a lot of creative professionals, this is fine. Lots of lawyers would probably disagree with me on that, but creative contracts like client agreements, contractor agreements, they're complicated, but it's not rocket science. You can totally buy a template online as long as you trust the source. I sell templates myself. I'm actually starting to release courses where I'm teaching like Kajabi courses where I'm providing legal education and templates as well. So I sell those on my website, but there's other providers out there too. It's not just me doing this. Anyway, those are usually pretty cost effective. My templates, I think, are $225 or something in that ballpark. Sometimes you'll see templates for $500 or $600. Sometimes you'll see them for $50. Sometimes you'll see them for free. They're free for a reason. I generally would avoid the free stuff. I'm not saying it's all bad. I'm just saying a lot of the free stuff is not really that great. If you can afford a couple $100, it's worth it to buy a template from a reputable source. Okay, now we're going to talk about the two most common formats for contracts that you as a creative professional are likely to see. The first format is a single project agreement. What this is you have one document, has everything in it. It might have exhibits or attachments like proposals or whatever, but it's one agreement. You sign it, you do the work, you get paid, the agreement closes or terminates, expires, whatever. Over. Client wants you to come back and do more work later, you're going to sign a whole nother agreement. And there's nothing wrong with that format. Most contracts are probably done in that format. But there's a better format that a lot of creative professionals can benefit from, which is the MSA SOW approach. And if you just Google MSA SOW, one of my guides will pop up and you can actually just read a whole bunch about this, but I'll give you a quick intro here. So the legal terms go in the MSA, the Master Services Agreement. That document says who owns the intellectual property. It says you'll protect each other's confidential information. Might have some default payment terms, non-solicitation, things like that. Then you've got one or more SOWs. And the SOWs are statements of work or scopes of work. And those contain project-specific deliverables. So no legal terms, but usually no legal terms, but you could put legal terms in there. So you might sign an MSA for 5 years with a client. SOW number one could be a marketing strategy, and maybe you spend 6 months building a marketing strategy for the client, and they pay you $5,000. Okay, great. Marketing strategy is done. Sign SOW number two. Now you're going to build them a website. Right? SOW number three might be you're going to maintain that website. Right. So each SOW is for a specific project. Now, when you create contracts in this format, you just need to be very careful to make sure that the SOW properly refers back to the MSA and that the MSA properly references the fact that you're going to use SOWs. The format is a bit more complex. It's not, again, it's not rocket science, but it is a bit more complex than the single project approach or the single agreement approach. But the beauty is, as a freelancer or a creative professional in a small business, you can sign an MSA for 3 to 5 years and then just do all your SOWs as needed without having to renegotiate all the legal terms. And so often you can do SOWs without involving lawyers. The other side, your client, they often can approve them without involving their legal department, which is a big plus for you. So anyway, I like the MSA SOW format quite a bit. Most of the contracts I sell and draft are in that format. Okay, there are 2 contracts that are going to be the most common contract for creative professionals. You've got client agreements and contractor agreements. You might have employment agreements if you're hiring employees, but most creative professionals, at least in their earliest days, are not hiring employees, but rather hiring independent contractors. And there's a lot of reasons for that. We're going to walk through a lot of essential contract terms and talk about how to negotiate agreements and so on. And we're going to primarily focus on these 2 kinds of agreements. All right, and keep in mind, if anybody has any questions, feel free to put them into the Q&A box. All right, so essential contract terms for creators. We're going to go through all 7 or whatever of these because these are the ones that I think are the most important. There are going to be more. Your contract's going to have a lot more than this, but this is the core stuff of what you need to really be focused on. First up, the parties. When you identify a party in a contract, you usually put their name in 2 places. First, at the top in what's called the preamble, and depending on the format of your agreement, this can look different ways. But a traditional agreement might say this client agreement is effective this date between party A and party B, and that's where you put your name. But it may not be your name, right? So if I'm signing a contract for my law firm, I don't put Chris Brown up there. It's not this agreement is between Chris Brown and client, but rather it's this agreement is between Pixel Law LLC, a Missouri limited liability company, and client, right? And by identifying my LLC at the top of the agreement, it makes the party to the contract my company and not me. So if something goes wrong, they can sue my company, and they might be able to sue me if it was me doing the work, but the contract liability sits with the company and not me as an individual. And that's a huge point. So if you have a business entity, make sure you name your business at the top and not you. If you don't have a business entity, that's fine. You can just use your personal name. The second place you put the party name is in the signature block, and this is what it should look like. So there are 2 ways you could do it. If you're an individual, you use the one on the left. Literally just sign your name, print your name, easy. For businesses, you need to follow this format or something like it. And it's really important you do this. If you don't do this, let's say you name your business at the top of the page, but in the signature block, you have something like this. So the business was named at the top, but an individual signature was provided. It's possible that a court could find that the party is you as an individual and not your business. So don't do that. If you have a business, name your business at the top and then use this format. Business name, sign it, print your name, and print your title. Title could be president, CEO, managing member, whatever. Whatever title you pick for yourself, just be consistent. And I got a question over here. Will the recording be available? I believe so. I got to figure out how to do that. My other session this week is done with the Innovate Her, and they're going to post it on their YouTube. I will find a way to share this with everybody later. And if nothing else, at least I can share the slides via email. Okay, so that's how you sign the agreement. You can use e-signatures, ink signatures, doesn't matter. Just use the right format. Okay, services. So what I see a lot of creators do in the service area is they don't provide enough detail, right? They might say, Gene will build a website for Bob. What does that mean, right? How many pages? Who's going to write the content? Where are the photos coming from? How many different page layouts are there going to be? You need to provide all of that detail. The more detail you can provide, the less likely you're going to find yourself into a dispute. And even if you do find yourself in a dispute, the easier it's going to be to resolve the dispute, because you can just look back at the agreement and say, look, you agreed to do 5 pages, not 2 pages. I want the last 3, right? And this is important for both sides of the deal. So provide as much clarity as you can. If timeframes are important, include that too. If you've got phases, maybe you're doing 2 weeks for wireframes, 4 weeks for developments, and 2 weeks for revisions or something like that, right? Provide that in the agreement. That way everybody knows when things are going to be due. That's especially important if you're the client hiring somebody. And then sometimes you should say what's excluded from the agreement. So website development example again. Say you're building a website. Well, is hosting included? Are you going to host it before you launch? What about after launch? You know, maybe stock videos are not included, but stock photography is included, right? Sometimes it's important to explain what is not included so that there's no disputes between the parties. Related to this is payment. So Bob will pay Gene $2,000. Okay, that's great. It's a good thing to have that in writing, but there's a lot of details missing, right? So what's the process? Does Gene have to send an invoice to Bob to get paid? And if so, how often, right? Is it payable in installments, maybe 1,000 up front, 1,000 after, or is it all paid at the front or all at the end? If it's paid up front, or if part of it's paid up front, is there a deposit, like a refundable deposit? I mean, if the project gets canceled, do you have to give any of the money back? Also think about reimbursable expenses. I mentioned in the context of a web development project, you know, what about stock photos? Who's going to pay for that? Who's going to pay for hosting, right? Who's going to pay for plugins if you need a premium plugin, for example? All of that stuff should be in the payment provision. Your payment provision is usually going to be at least a paragraph, if not longer. Sometimes it's a paragraph with a list of other expenses or items or add-ons or whatever it might be. I also have a note there about, especially if you have subs. So think about if you hire subcontractors. Maybe you are a marketing agency and you subcontract out the actual development of the website itself. Well, if your subcontractor needs to be paid half up front and half at the end, you should probably make sure that your client is paying you half up front and half at the end so that you can, you know, run that cash flow. You don't want to be out of pocket a bunch of money to a sub if your client's not paying you to the end. So it's often very smart to look at the client agreement in relation to the subcontractor agreements to make sure that everything kind of lines up and that you're not going to find yourself in a weird middle spot where you owe money to somebody but haven't been paid yet by your client. So here, I mentioned in my product description or the session description, I was going to give you some sample language. So here's one of them. This is payment language. And you're welcome to screenshot this, or I'm also going to send this out afterwards. But basic payment options, here's two of them, hourly and fixed fee. The first one is hourly, and you know, it just says here's the hourly rate. It says that the contractor will invoice the company, the client, monthly. Maybe it's every other week, maybe it's at the beginning, at the end, whatever. And that the company will pay all undisputed amounts within 30 days of receipt. Right now, this doesn't include everything you can imagine, but it's a really good start because it outlines how it's going to happen. Alternatively, you might use this fixed fee paragraph where the company has to pay the contractor $5,000. And then you use this format where you bullet out each individual payment. So $2,500 is due now, or 7 days of the SOW, which is a non-refundable deposit, right? Another $1,000 might be due in January, another $1,500 due in February, right? Or if you want to replace one or all of those with phases, you could say $1,000 upon the contractor's completion of the services, right? Or you could say completion of phase one or whatever it might be. Point is, you outline the total amount here and then break down all the individual payments below it. It's very clear when things are due. So it's unlikely the parties are going to get into a dispute about, you know, whether or not you actually owed that second payment on January 1st, for example. All right. We're going to jump into intellectual property now, which is one of my favorite topics. So intellectual property makes up something like 80% of the value of all S&P 500 companies, right? IP is huge. And as a creative professional, it's extremely huge for you. If you're creating something, especially if it's intangible. Now, if you're creating t-shirts or purses or bags, whatever, it's important, but not as important. But if you're creating like websites or marketing materials or videos or ebooks, this is a huge topic for you. There's four main types of IP. There are copyrights, which protect primarily creative works, dance, music, art, also business documents, computer code, website, stuff like that. Trademarks, which protect primarily branding elements. So things like your company name, your slogans, your taglines, product names, things like that. Trade secrets, which will protect confidential information. And in this regard, you can and should use non-disclosure agreements. But there are also federal and state trade secret laws that you can use to protect your confidential information. And then last is patents. Patents are probably the least relevant for most of you. Depending on what you're doing, they might be very important if you're inventing things. If you are inventing things, then you should probably talk to a patent lawyer. I'm not a patent lawyer. I know about patents, and I certainly know the other three areas very well, but I don't have an engineering background or a science background, so I never took the patent bar or any of that stuff. Now for creatives, copyrights are probably the most important. So I want to talk through a little bit more about copyrights. This kind of applies to other areas of IP as well, but it's primarily geared around copyright. And again, copyright is protecting creative works, music, art, dance, website copy, business documents, presentations, ebooks, all that creative stuff. Now, there are three common ways that you will see copyright, well, more generally, intellectual property assignments in an agreement, at least if you're signing a client agreement. So this is when you are the creative professional and you're signing an agreement with your client. You're making something and the client wants to own it. There are three main ways that I see this going down. One is you, the creative professional, retains ownership of everything, right? If you do that, the client's going to need to get some kind of a license from you to use the work, right? Because if you don't license it to them, they can't use it. So if you build let's use a photographer as an example, but photographers are unique in that they have successfully built their industry around this concept where photographers tend to continue owning the rights to the photos they take, and then they grant a license to their clients to use those photos. They're unique in the creative world because usually the client captures ownership, but photographers generally don't do that. So in that case, a photographer will take the photos, they own the photos, and then they give a license to the client to use those photos. It might be a perpetual license. It might be just a license for 1 year. It might be a license for non-commercial purposes, or maybe it is for commercial purposes. Point is, the photographer gets to make those decisions. Second option is you just assign it to them. And what I mean by that is in your client agreement, you say, I, the photographer, hereby assign all of my work product to you, the client. You would usually say after you pay me, like the transfer usually shouldn't happen until the payment's made. But the idea is the client owns everything. If you do that, keep in mind, you, the creative professional, cannot necessarily use those photos anymore. Your client owns them. You put them on your website, that's copyright infringement. So if you want to use any of your works that you've assigned to a client in your own portfolio, you need to get a license back from them to use it. It could be as simple as a sentence in your agreement that says the contractor can, use the photos or the work product in their marketing materials, or you could get more explicit and outline exactly how that works. So first option, you own it. Second option, client owns it. Third option, split it. You own the underlying assets while your client might own the specific works. So let's go back to the example of website developer. A lot of website developers work in WordPress. They might have their own themes that they reuse in multiple clients. If you give the entire website build to your client, including all intellectual property rights, copyright in that website to your client, you can't reuse that theme, right? And that creates a pretty big problem if you use the same theme with multiple clients. And this applies to any other industry as well, not just website developers. So oftentimes what I see, and this is probably the most common, the creative professional retains ownership of the underlying assets, the core assets. And you usually define that as, assets that the contractor might reuse with multiple clients or assets that the contractor builds not uniquely for the client. And so the contractor continues owning it, much like point one, and then you give a license to your client to use it. But then you give specific creations to your client. So if you write a bio page, or if you write a paragraph about a business, well, the client can own that. You don't need to reuse that, right? So the client owns the specific works you created for the client, but you retain the underlying or the core assets. Now, this is all in the client relationship. Let's say that you hire an independent contractor underneath you or an employee underneath you, right? You pretty much need to get ownership of everything. If you are hiring a subcontractor to work on your client's project, you need to get ownership of whatever your subcontractor is creating so that you can do one of those three things at the top. Either you own it or you give it to your client. If you don't get it from your sub, you can't then transfer it to your client. You don't own it. And that's a big problem that I've seen people fall into is they hire a bunch of subcontractors, but don't use the right kind of agreement. And now, once again, they're stuck in the middle where the client says, well, I need to own this. And the subcontractor says, no, you didn't pay me enough, right? So just always think through how that works. Most often, you're just going to say that you want to get everything. So here's some, oops, button's not working. Here's some example language for when the client owns the unique work, but the contractor retains the underlying works. And once again, if you want to take a screenshot of this, feel free to do that. I'll send this out later. But what this does is it outlines that the the intent of the parties is for the client to own the works. So the intellectual property is being assigned to the client via this sentence here, according to the service provider hereby assigns. Right? But then I say some of the work product, and work product is a defined term up here, may incorporate some of the service provider's pre-existing works and works it creates for multiple clients, which is this sentence here. And so it goes on to say that those service provider works will be retained by the service provider. But again, remember I said if the service provider owns it, they might need to grant a license to the client. That's what this is. However, the service provider hereby grants, right, a license to use it. And here's the terms of the license: perpetual, irrevocable, worldwide, so on. This paragraph I've been using for years, or something similar. It's always kind of tweaked a little bit here and there, but more or less this concept I've been using for years, and it usually works well. And I think if you use it in your agreements, I mean, I'm not your lawyer, of course, I can't guarantee it'll work for your specific deal, but this is language that I've used for a lot of deals, and it would probably work for a lot of your deals. Okay, confidentiality. I mentioned earlier that there are federal and state trade secret laws, and that those kind of mirror confidentiality concepts. But I also mentioned you should just use non-disclosure agreements with people. So an NDA could be a standalone NDA, or it could be just a confidentiality paragraph in your agreement with your client or sub or whoever. Usually it's just a paragraph inside of your agreement. Regardless, these are the concepts you should be thinking about when you're dealing with a confidentiality paragraph or non-disclosure agreement. First, is it unilateral or mutual? And the difference is, if it's unilateral, both sides are agreeing to protect the confidential information of the other side. If it's mutual, only one side is agreeing to do that. So you get a job with Cerner, big company in Kansas City, they have a lot of contractors. Cerner is going to fully expect that you're going to protect the confidentiality of all of their information. Odds are Cerner is not going to agree to protect your confidential information. They don't want a whole bunch of NDAs floating around that could trip them up in some way or another. I'm not saying they never do it. I'm just saying that when they're hiring like a freelancer, for example, they probably are not likely to agree to a mutual non-disclosure paragraph. Again, this is just broad example. So anyway, unilateral versus mutual. Second up is that there's usually three obligations that you'll see: protect, don't use, and don't disclose. Protect is you will protect the other party's information. Don't use means you won't use their confidential information unless you're using it for their benefit. And don't disclose means that you won't disclose it to third parties. You won't publish it on the internet. You won't put it in a Dropbox link that's publicly available, and so on. Next up, you'll usually see a definition of what does it mean to be confidential. And it usually starts out with like confidential information means, and then you outline what is confidential. Sometimes you'll see all kinds of things thrown in there: business documents, financial plans, projections, yada, yada, yada. That's fine. You could do it that way. Lots of lawyers love doing it that way. I personally don't like doing it that way. I prefer to keep just kind of a broad definition, which says confidential information means anything that a reasonable person would deem confidential under the circumstances, right? And I usually also loop in third-party info that you might be holding. So say that you're working with a client to build a website. Again, this example keeps coming up. And your client's going to tell you about their marketing plans, their target clients, all this stuff, right? Confidential info. They don't want you to disclose it. Well, when you sign a contractor agreement with somebody who's going to help you working on that website, you need to make sure that you have a confidentiality paragraph in your contractor agreement, your subcontractor agreement. And you're going to want to make sure that the definition of confidential information not only includes your info, but your client's info, right? Because you're going to be giving some of your client's info to your sub down the chain. And you need to make sure that your sub is going to protect your client's info in addition to your info. Now, there's probably going to be some exceptions to the obligations of confidentiality and exceptions to what is deemed confidential. Things like information that falls into the public domain, for example, is no longer deemed confidential. You might need an exception to the disclosure rule. So you can't disclose it, but you might be allowed to disclose it to your subcontractors and your employees, provided you have an agreement with them in place, right? And then last, consider the length of the obligation. So sometimes it's 1 year, 5 years, sometimes it's perpetual. You just need to think about the info being shared and decide how long does that obligation need to go after the project is over. Okay, non-solicitation is a big topic. There are two sides to this that you should be thinking about. This is when you're signing a client agreement, you want to prevent your client from poaching your workforce. And then the other side is when you're working with subcontractors or employees, you want to make sure that they are not going to poach your clients. So let's dive a little bit deeper into this. Again, website development example. It's just so easy to use this example. You sign a contract with a client to build a website. You subcontract out some of the web development work, or maybe the copywriting work, whatever. You don't want your client going around your back and hiring your subcontractors or worse, your employees without going through you, right? That could wreak havoc on your business. So you'll usually have a non-solicitation paragraph that says, while you're working together and for some period of time after your relationship ends, so usually about a year, the client won't go after your workforce. And when I say workforce, I definitely mean employees, and sometimes, often I mean contractors. You don't want them poaching your workforce. On the opposite side of that, you don't want your workers poaching your clients. So if you hire employees or contractors, same thing, put a non-solicitation paragraph in your agreement with them. And that provision is going to say, while you're working with my company, and for some period thereafter, usually like a year, you will not solicit, so you won't call upon, or provide services to any of my clients. And this is a way to protect your client base. Now, I will note this is not a non-compete. A non-compete literally says, hey, employee, after you quit working here or I fire you, you cannot provide any competing service, usually within like a year and like 25 miles or so of your business, right? Non-competes are very restrictive. You usually only see them in the employment context. You don't normally see them in contractor relationships. And it makes sense, right? Because a contractor, the whole nature of their business is they're going to have multiple clients, often in the same industry, right? Whereas employees, they typically don't. Employees usually only have one employer or maybe two at most. I don't like non-competes. I think they are, not only do I think this, but there's studies, the Kauffman Foundation, for example, has studies on this, and they've proven that it has a negative impact on wages. It has a negative impact on worker mobility. And it just creates problems. I generally don't like non-competes. I do like non-solicitations though. Non-solicitations are very smart to protect your business, and they don't overly burdensome the worker. The worker can go find other clients. They just don't need to steal your clients, right? It's not that burdensome, in my opinion. All right, moving on to term and termination. And once again, remember, feel free to put questions in the chat, the Q&A window. Having that dialogue is my favorite part of talking, and best way we could do it via these kind of Zoom events is just to put it in the Q&A. Now we're going to talk about term and termination. Two things here, term and termination. Term, do you need to set the term? Do you need to set a length of the agreement? And usually you should, especially if you're an independent contractor, because contractor relationships are supposed to be term limited to some degree. Earlier, I mentioned the MSA and SOW format, and if you're doing that, then your MSA might be a longer term, might be like 5 years, even though you have no idea what you might be doing in year 4. But the MSA agreement, 2 years, 3 years, 5 years will usually stretch on much longer than the SOWs will stretch on. The SOWs are usually going to be like, 6 months or 1 year, or maybe even just a couple of weeks. Anyway, make that clear in the agreement. And make it clear, when does it expire? You generally don't want to have a perpetual agreement. I do see that. Sometimes I see a perpetual MSA. I don't like perpetual agreements. Perpetual is a long time, right? And there's just a lot of ambiguity about what happens in year 8 or year 10 or 12, right? Plus, having an expiration date gives you a really good opportunity to either walk away and not renew it, or to renew it and renegotiate terms. Maybe that's a good time to have a conversation with your client about changing things. Right. So anyway, for an MSA, 2 years, 3 years, maybe 5 years makes a lot of sense. Next up is consider, can you or they terminate early? You just have to go through this in your agreement. Doing this gives you so much more power in the client throughout the relationship. So voluntary by you. Can you just say anytime, hey, I quit, right? You know, if you're an employee, that's normal. That's normal. If you are an independent contractor or a company with a client agreement, that's not as normal. You normally can't just quit anytime, right? Normally, it's 30-day notice, for example. You can terminate the agreement anytime, 30 days notice. And that gives the other party 30 days to figure out what to do when this relationship is over. Conversely, think about the client, the other side of the deal. When can they terminate early? You know, if you're an independent contractor with 5 clients, you don't want your client to be able to fire you without notice, right? Because then you're going to have to go out and find replacement work. So a 30-day termination window makes sense in that scenario as well. But maybe you don't like that at all. Maybe the sides say, look, this is a 6-month commitment. Neither side can terminate early. It's a short-term project. Just do the work, get the payment, be done. No termination at all. If you do that, or even if you do have the 30-day notice, and to be clear, 30 days could be 90 days, 60 days, 15 days, whatever makes sense for you. Regardless, you might want to have that third bullet point, which is breach and cure. What this is a provision that will say if one party is breaching the agreement, then the other party can provide notice of the breach and will be allowed to terminate immediately if the breach is not cured within some amount of time, 5 days or 10 days. It's typical. So say that you are doing a website. I keep coming back to that example, a website for a client, and you just stop working, you just kind of disappear. Well, the client can send you notice and say, hey, Bob, where'd you go? You've got 10 days. If you don't catch up in 10 days, we're terminating the agreement. If Bob doesn't fix it, then the client can terminate 10 days later. Vice versa, maybe the client's not making progress payments to you. Same thing, give them notice. If they don't pay you in 10 days, you can cancel the agreement. And it's just a way to get out of the agreement if there's fighting going on or if somebody disappears or whatever it might be. The other thing you should think about with termination is what happens after the termination. Usually the client has to settle up, make some kind of a payment. I don't remember if I have, no, I don't think I have it in here. Normally the client has to make some kind of a settle up payment, pay off whatever's owed for outstanding work. Sometimes work product has to be delivered at that time. Just kind of think through what happens after the fact. And here are some examples, language you can use. And again, feel free to screenshot this. The first sentence says that the agreement cannot be terminated except as provided in the agreement. And that's just kind of creating the overall structure of the relationship. Second paragraph is either party can terminate with 30 days notice. And you might change either party to the client may terminate if it's only on the client side or contractor side or whatever it might be. And of course, you can change the number of days. And then the last paragraph is the breach and cure paragraph. So either party can terminate immediately if the other party fails to cure a breach. Again, these are provisions I use quite a bit, or at least similar to the provisions I use quite a bit. They'll probably work fairly well for most of you. All right. Now we're going to go through reviewing and negotiating agreements. And I like to think of the review stage as kind of a 5-step process. First up is knowing your expectations. And let me back up, actually. Knowing how to review a contract comes into play when somebody gives you a contract to review, right? That's kind of obvious, but if you are a creative professional, I guarantee you're going to run into somebody giving you a contract, and you might just look at it and be like, what is this? This is confusing. I don't get it. Maybe it's a 20-page agreement, which is usually overkill. And you can always hire a lawyer, of course, to help you. I do contract reviews all the time. Lots of lawyers do. You might just ask a lawyer to look at one paragraph, or you might just read the whole thing yourself. And these are the tips for how to do it yourself. And even if you do hire a lawyer, it's good to do these things before you give it to the lawyer, so you can tell the lawyer what you're looking at. So first thing is know your expectations. What is it that you want out of the agreement? If you are developing a marketing strategy for somebody, what do you need from them to do that? And what do you need to get paid? And when? And also understand the other side's expectations. They're going to expect a marketing strategy, but what does that mean, right? Is it a 30-page PDF? Is it a 1-page summary? What is it, right? What are the expectations of the parties? You cannot review a contract if you don't know what it is you want out of the deal. Then I recommend you review the services and payments. And this is kind of the core of the agreement. It's what are you doing and what are you getting paid, or vice versa. That's one, and then apparently 3 goes twice. I should probably edit these slides. So the second bullet point there would be intellectual property. So who's going to own the intellectual property in the agreement or coming out of the agreement? Again, go back to that slide I talked about earlier. And then termination rights. You always want to know how you get out of an agreement. Once you're in it, it's smart to know how to get out of it. And then read the rest of it. And I really do mean all of it. I'm a dork. I like contracts. I actually enjoy this stuff. Most people hate it, but you need to read the whole thing. There could be a very important thing tucked away somewhere in section 45 that might be the whole world to you. So read the whole thing. Then consider, is anything missing? This is one of the biggest problems a lot of new lawyers and non-lawyers make, is they read the contract and they're like, okay, great. But they don't think about, well, what's missing? You know, maybe there's not a confidentiality paragraph when you need one to be there, right? And if so, you need to add it in. And then you need to think about making changes. And how do you go about doing that? First thing I'll say is don't be afraid to make changes, either yourself or through your lawyer. Contracts are negotiated. The vast majority of contracts, that I come across are negotiated in some way. It might just be changing one sentence, or it might be changing like every paragraph. It just kind of depends. And you got to think about, how do you go about doing that? Sometimes it's like, hey, you just email them back and say, hey, section 4, can you make it mutual? Great. Other times the changes are more complicated and you need to turn on track changes in Word or Google Docs, wherever it is that you're editing the agreement, and track all the changes to show to the other side. Don't just make changes and send it back, right? You need to track them in some format so people can see what it is that you're doing. It's best to, actually, no, my next tip is on the next slide, so I'll come back to that in a second. Somebody asked a question here. The question is, what if you've already done the work, workbook design, for example, but the client doesn't like it and doesn't want any revisions and wants to do it themselves, so they want to stop from moving forward? How do you cover yourself, the service provider, for doing the work even though the client didn't like it? Oh, well, unless the client has, okay, so let me back up. This question is, you've done the work, the client doesn't like it, they don't, I suppose they don't want to pay you maybe. What do you do, right? Well, you can protect against that in the agreement. That's what all of this is about, right? Sometimes clients will have approval mechanisms in contracts where they don't have to pay you until they approve the content. And if so, you just need to carefully negotiate that language to make sure that the approval has to be reasonable, right? They can't just get to the end and be like, I don't like it, right? No, they need to give you suggestions, and you should have the right to cure whatever those objections are. If they say, I really hate the colors you chose, well, first of all, you should have gotten the colors approved up front. But second of all, okay, fine. You get the opportunity to fix the colors, and then they have to pay you, right? Other things you can do are having non-refundable down payments. And I really like this one. I talked about this on the payment slide. Say it's a $5,000 project, say that they have to pay you $2,500 upfront, and that's non-refundable. You know, maybe it's refundable if you're in breach, you know, you just disappear or don't do anything, fine. But aside from like you just totally screwing up, it's non-refundable. And that's one of the best ways to protect yourself. You may not get the full $5,000, but hey, at least you got half of it, right? You could still go after the other chunk if you want to hire a lawyer or make threats against them, but at least you got some of the money up front. Those are probably the two best suggestions. I think the non-refundable deposit is the best one. If you're already in the situation, the advice I gave you is horrible. It doesn't help you if you're already in the situation. If you're dealing with that situation at this moment, the best thing to do probably is hire a lawyer. It depends on how much money is at stake. If it's a $500 project, it's not worth hiring a lawyer, to be honest. Unless you're just doing it out of principle. If it's a $5,000 project or a $500,000 project, yeah, it makes a lot more sense to hire a lawyer at that point. And a lawyer can look through the scenario, the fact pattern, to see, you know, what work was done, whether or not you have good claims under the agreement, and so on. Which reminds me, one other thing, you can also have an attorney's fee provision in your agreement. And the attorney's fee provision can say that if the client fails to pay you and you have to hire a lawyer, that you can go to the, and assuming you win your case, that the client has to pay your legal fees. And that makes it a lot easier for you to hire a lawyer if you think you have a good case, because if you win, you can get the client to not only pay you, but pay you your attorney's fees. All right, now let's talk about how to actually how to negotiate an agreement. So, and this is actually going to be my last slide, substantive slide. So again, I love your questions, so keep them coming in the Q&A box. And we'll have plenty of time at the end here to talk through those. So contract negotiation tips, understand your bargaining power. I mentioned earlier, like if you're working with Cerner, for example, you're not going to probably be able to negotiate for too much stuff. They're a big company. They're going to say, here's the deal. There's plenty of contractors that want this job. Take it or leave it. I don't love that, but Bigger companies tend to have that kind of power. So if that's your situation where you're negotiating with a really big company, it just might have to accept that you're not going to love the agreement and then make the decision of whether or not you want to take on that project. Ask questions. That's the second one. Having a dialogue is usually one of the best ways to resolve issues that you're going to find in an agreement. Sometimes you'll ask a question like, why is this provision here? This actually just happened to me last week. I was reading a contract and there are 3 whole paragraphs in different areas and I'm like, what is this talking about? So I asked. Turns out they left it in there by mistake from a prior deal. Fine, easy, delete it, right? Something that might just seem totally unreasonable in an agreement might just be worded wrong, and the other side may not even know it or realize it. So asking questions and creating that dialogue is huge for negotiation. Third up is adding and removing things as needed. Look, this is your livelihood. Don't be afraid to add stuff or remove stuff. If a provision is unfair to you, change it. Again, there might be scenarios where if you're contracting with Google, you may not be able to do that. You just may not have the power to do that. But for most contracts, you can add and remove things as needed. And you might have to go back and forth, but the point is to do it. Next up, use track changes. I did talk about that on the last slide. If you're going to make changes, make sure you're doing it in some way that people can see what changes you're making. And then last, try to keep their language. So they might send you an agreement. There might be a paragraph about intellectual property that you just hate. The language is bad. You prefer to own the content and the client wants to own it and you just don't know what to do. You could just delete the paragraph entirely and insert a new paragraph, but it's usually a good idea to try to use their language whenever you can. Deleting an entire paragraph and replacing it is kind of a bold move, and I do it for sure sometimes. But whenever I can, I try to use their language and just modify it, modify sentences or words within the paragraph instead of deleting the whole thing and replacing it. All right, I see some questions coming in. I'll address those in just a couple seconds here. Here's my basic info. I'm on Twitter and Instagram at the Pixel Lawyer, and you can email me anytime, chris@pixellaw.com. My contact info is also on my website. Well, I don't think that email is, but on email is on my website. Feel free to reach out anytime on social platforms or via email. So let's jump into some of these questions here. And I think I saw something about somebody raising their hand. I honestly don't know how that works in the context of a webinar, but I'm assuming that person put a question in the Q&A. Let's see here. First question, what are some good recommendations for lawyers that work with creatives here in KC? Are you asking, you are a lawyer and you're asking for help with how to work with creatives, or are you asking for referrals to lawyers? And maybe you can clarify that in the Q&A and I'll come back to that one. Savannah, how important is trademarking early? Do you recommend it before launching? Of course, researching. Yeah, trademarks. I mentioned earlier, trademarks are intended to protect branding elements like your company name and so on. The general advice is to file a trademark registration, or I'm sorry, file a trademark application for a registration as early as possible. You don't have to file. You actually get common law trademark rights as soon as you start using a name in commerce. However, a registration is very important, and coupled with doing an application is doing the trademark search. You can run a search on your own. You can go to the trademark office website and start searching there. You could hire a search company for you. There's one that I use called Markify. They're awesome. Running a search on your own, for example, they charge $129. Running a search on your own is great, but if you don't know how to read it and interpret it, it's not overly helpful. So you usually want to work with a lawyer to run that search and review the search, because reviewing it's what really matters. Anyway, you run the trademark search to see what names are out there. You don't want to pick a name that somebody else has already been using, because then you're just going to run into trademark problems. You want to pick a name that is as arbitrary as possible, because you have greater trademark rights in an arbitrary name. And that's the legal advice, but the practical advice, the marketing advice is that's horrible, because picking an arbitrary name means the community will have no idea what the product is. So there's a balance between picking an arbitrary name and picking a descriptive name. Anyway, if you decide to go down the trademarking route, the application fee is usually $250. It goes up if you have a bunch of goods and services classes, but you should do that application as soon as you possibly can. When somebody goes through me, just as an example, it's usually about $1,450 all in to do the search and the application, and that includes the filing fee. Other lawyers charge different amounts. I say that in the sense of the moment that you can afford $1 to $3 grand, to file your application, you should do it. If you're Coca-Cola and you're releasing a new product, you're going to do that on day one. Just, because they have the money to do it and they invest millions of dollars in their products. If you are a freelance graphic design artist in Kansas City, you may not do that on day one. That $1,500 might be better spent on marketing or buying a computer or something else. And I get that. So, but anyway, the advice is to do it as early as possible. I do trademarks, so feel free to reach out anytime if you want to talk about that. There's also plenty of other trademark lawyers across the country. Okay, back to the question about recommendations for lawyers. This person is a photographer and asking for referrals for lawyers. First of all, I'll say I work with photographers a lot, so feel free to reach out with me. I am one of the first courses I'm going to release actually is going to be a course for photographers on how to do client agreements, second shooter agreements, how to deal with copyright and all that stuff. That's not going to be out too soon, but I am working on it. But you're welcome to hire me or reach out to me. I don't know any other lawyers in Kansas City that are specific for photographers. Trying to think off the top of my head who else might be a good fit for that. I know Siegfried Bingham is a really good firm. They've got like 50 or 60 attorneys. They're not gigantic, but they're also not tiny. So they can kind of do almost everything. I really like that firm. If you want more specific referrals, reach out to me and I'll see if I can figure that out. Okay, we've got another question. It's all too common to receive a contract that was based on boilerplate. I too have found random things that didn't apply. Yeah, I mean, people find stuff online all the time, copy and paste it in, and it's crap. and so many contracts have just been copied and pasted over the years, and you end up with just kind of a really bad contract, and that's not very good. Ricky's asking if we're going to send the video and slides. The slides definitely will be sent out. The video, I need to figure out the easiest way to get that out to everybody. I am recording this, but since I'm the only host and I don't have a YouTube channel, I just need to figure out the easiest way to get that out. But at a minimum, the slides. Okay, that's all I have. If there are no other questions, we can wrap this up. Oh, here's a question. Do you suggest having a smaller contract for little freelance jobs and a more in-depth one for larger jobs? That's a good question. The length of the contract depends on the complexity of the deal. So if you're doing a $500 photography project, for example, you don't need a 20-page agreement. The risk is just so small. If you're building a deck for $500, I don't know why you'd be doing that, but assume it's a low dollar amount, but you're doing something risky like building a deck, right? That's physical labor. All kinds of risks. You should have insurance things in there. You should have indemnification language in there. You should have all kinds of quality control things in there. So my point is, it comes down to the risk involved in the agreement. The dollar amounts are a factor, but also the services being offered are a factor. And actually, maybe the deck building might be a bad idea. Let's say you're a cybersecurity expert and you've got a tiny little project. It only takes a few hours and you only bill $500. Dollar amount might be low, but cybersecurity is huge. The implications of making a mistake is millions of dollars in damages. So again, the risk is huge. The more risk you have, the more the longer the agreement is likely to be. The less risk you have, the less longer, or the shorter the agreement is likely to be. And I say that because the deck example or the cyber example, if you have a lot of risk, then you're going to have insurance provisions. The more risk you have, the longer those insurance provisions are going to be. Instead of it saying the contractor has to have insurance, it might say the contractor has to have these kinds of insurance policies with these kinds of limits. It might go on to say the kind of insurance company you have to use, the insurance rating. It might go on to say that you have to provide a certificate of insurance and name the other person as an additional insured. It might have waiver rights, right? It might have more stuff, right? Because the liability and the risk is so large that you just have to have additional provisions. Same thing with intellectual property. So if you're going to own the intellectual property rights, it's easy. Contractor will own rights, right? One sentence. If the client's going to own the underlying works, but you're going to, or I'm sorry, the specific works, and you're going to own the underlying works, then go back to that paragraph I showed earlier, right? Which is obviously longer than one sentence. My point being, the more risk involved, the more provisions you need to add, and the longer those provisions become. So there is no magical length for a contract. A lot of people like to try to keep a contract to a page or less just because it sounds better or it looks better, which is kind of true. But what you need to do is make sure the agreement is the length that it needs to be to cover all the risks that are in the contract. Okay, got a couple more questions coming in, which is wonderful. I love these questions. In the K to 12 context, is curriculum you developed while working at a school the IP of the school? If after leaving this job, a consultant create curriculum using work I originally created while employed, could my former employer claim ownership of my current consultant work? That's a very good question. Mostly what you're talking about probably, and then let me rephrase the question. So your question is, does your employer own the creations that you worked, and can you use those creations after you leave that employment? Generally what you're talking about is copyright. Copyright protects creative works. So the question is, who owns the copyright? Under the Copyright Act, the party, or I'm sorry, an employee that makes work within the scope of their employment automatically transfers all of the works to the client or to the employer. The employer owns everything. If you're working as a janitor in a high school and your job is to sweep floors and you go home and you write some great curriculum, you're probably going to own that curriculum. Even though you work for a school, your job wasn't to create curriculum. Your job was to sweep floors. Right? Let's say that you were a vice president of a school district and your job was to create curriculum, and you go home at night and make some great program. Your employer is probably going to be able to claim ownership. It falls within the scope of your employment, squarely within the scope of your employment. If the school district or your employer owns that content, then when you leave, they still own it, and you probably cannot use it without their consent. Now, this is all very general advice here. So like your specific situation might be different. You should probably talk to a specific lawyer about this. And again, you feel free to reach out to me. It's very fact specific, but generally speaking, the employer will own everything the employee makes within their scope of employment, which means the employee cannot use it anywhere else. Since I'm saying that, I might as well tell you the exact opposite thing too, which is if you hire an independent contractor, it's the opposite. Independent contractors will own the works that they create, at least copyrightable works, unless there's some kind of an assignment in writing going to the client. So employees, everything is owned by the employer. Contractor, everything is owned by the contractor, unless you change that in writing. All right, and also real quick, I have an ebook on my website all about intellectual property. It goes much more in depth on the copyright stuff if you want to go check that out. It's an intellectual property ebook. All right, that's all the questions that I'm seeing in here. Thank you all so much for joining. I do have another session tomorrow with Megan Hovey from Hovey CPA. She's an accountant, and Lauren, trying to complete bank on Lauren's last name. I can't believe that. Lauren from Innovate Her, who's going to be moderating a discussion with Megan and myself on how to start a business. We're going to talk about LLCs and a little bit more about contracts. We're certainly going to talk about the accounting aspects of it. How do you, get an EIN? How do you run your accounting through an accounting platform? All that stuff. That session is tomorrow at noon. I hope you guys can join me. If anybody has any other questions, feel free to reach out on Twitter or Instagram, I guess, or shoot me an email. I'd be happy to chat. So thank you all so much for joining me here today, and enjoy the rest of your global entrepreneurship week. Thanks.